Certiorari is a remedy in judicial review that allows a higher court to quash the decisions made by inferior courts, tribunals, or public authorities. It is invoked when these bodies breach the principles of natural justice, act beyond their lawful jurisdiction, or even commit procedural irregularities or make an error of the law that is apparent on the face of the record. The primary purpose of certiorari is to ensure that decision makers remain within the legal limits of their authority and that their decisions are made fairly, lawfully, and in accordance with established legal procedures. By issuing a writ of certiorari, the court ensures that these bodies act within their prescribed legal limits and that individuals are not subjected to arbitrary, biased, or procedurally unfair decisions. It serves as a critical safeguard to uphold the rule of law and ensure adherence to statutory procedures and protect the rights of individuals affected by public decisions. Through certiorari, the courts play a supervisory role, maintaining the integrity of administrative and quasi-judicial processes, reinforcing both accountability and public trust in governance.
Natural justice is a foundational principle in the legal systems of civilized societies, ensuring fairness in decision-making processes, not only within judicial courts, but also in administrative bodies, tribunals, and officials empowered to affect individual rights. It operates as a safeguard to ensure that actions or decisions made by authorities are just, impartial, and transparent. The concept of natural justice rests on two fundamental principles, often referred to as the twin pillars of the doctrine. The first principle is audi alteram partem, the right to be heard, and second, nemo judex in causa sua, the rule against bias. These principles form the cornerstone of procedural fairness, and the rule of law, ensuring that every individual is granted an opportunity to respond to allegations and that decisions are made by impartial adjudicators. Where these principles are breached, certiorari may be used as a legal remedy to quash such flawed decisions. The first principle, audi alteram partem, guarantees that a person has the right to be informed of any allegations made against them and be given a reasonable chance to respond. This includes the right to know the specific charges, the evidence presented, and the opportunity to counter or explain that evidence. Importantly, it also means that no evidence should be received or considered in secret behind the back of the accused party. A violation of this principle may be rendered a decision reviewable by certiorari, which ensures that courts and tribunals are held to standard of fairness. This principle was clearly illustrated in the case of Malayawata Steel Berhad against Union of Malayawata Steel Workers 1978. In this case, the plaintiff challenged a decision by the industrial court, arguing that they were not given the opportunity to present a key witness. By denying the plaintiff an opportunity to bring and examine a vital witness, the industrial court failed to ensure a fair hearing, thus undermining the fairness of the entire proceeding. Therefore, the Malayawata case is a strong example of how the denial of a party's right to fully present their case constitutes a violation of the audi alteram partem principle, making the decision vulnerable to challenge by certiorari. Similarly, in Fang Mohsin against Commissioner of Police and others 1967, the issue concerned the lack of adequate notice given to the plaintiff. The plaintiff had received only a single notice before the hearing and was not even provided with a copy of the allegations made against him. When he requested a postponement to prepare his defense, it was refused. The court held that this lack of proper notice amounted to a breach of natural justice, as the plaintiff was not given a fair opportunity to defend himself. Consequently, the entire proceeding was declared invalid. This situation clearly falls under the principle of audi alteram partem, which requires that a person is given a fair chance to be heard before a decision affecting their rights is made. In such circumstances, certiorari serves as a mechanism to set aside unjust decisions made without proper notice or hearing. The second core principle, nemo judex in causa sua, ensures that no individual can act as a judge in their own case, thereby preventing bias in decision-making. The rule against bias is expressed in the Latin maxim nemo judex in causa sua, meaning no one should be a judge in their own case. This principle of natural justice also reflects the right to be treated equally. When a person takes on the role of a decision-maker in a situation where they have a personal interest, they are assumed to lack impartiality. It is often said that bias disqualifies a person from being a judge. This rule is based on two fundamental ideas. Firstly, a judge must not be influenced by personal or financial interests. Secondly, it is not enough for justice to be done. It must also be seen to be done. If a decision maker appears biased, certiorari may be applied to nullify the decision, protecting the integrity and credibility of the legal process. To illustrate, in Metropolitan Properties Co. Limited against Lennon, 1969, the chairman of a rent tribunal, Mr. Lennon, had previously dealt with a case involving the same landlords and made remarks suggesting a negative view of them. Although he had no personal interest, the House of Lords found a reasonable suspicion of bias, ruling that he should have recused himself. The case reinforced the nemo judex in causa sua principle that justice must be both done and seen to be done. As a result, the tribunal's decision was quashed by certiorari to preserve public confidence in impartial decision-making and uphold the standard of natural justice. The second issue is excess of jurisdiction, where a writ of certiorari may be issued to correct jurisdictional errors made by inferior courts. This applies when a decision is made without any legal authority, exceeds the conferred jurisdiction, or arises from a failure to exercise the jurisdiction properly. Generally, jurisdiction refers to the legal power of a court to hear and decide a case and deliver a binding judgment. When a body acts outside its constitutionally or statutorily defined powers, its decision can be considered as made in excess of jurisdiction. Such actions can be annulled by certiorari, ensuring that public bodies do not act beyond the legal limits set by law. For instance, where a public authority makes decision through ultra-vires subsidiary legislation or misuses discretionary powers, certiorari may be sought to invalidate such decisions. To illustrate, in Wang Kwai President Town Council, Johor Bahru, 1970, a magistrate issued a demolition order for a house based on a health inspector's application. However, the law required that such an application come specifically from the president or deputy president of the council. As the proper legal procedure was not followed and the wrong authority initiated the application, the High Court found the order to be invalid. Certiorari was issued to quash the demolition order, as the magistrate acted without proper jurisdiction due to improper delegation. Similarly, in Tan Sri Eric Chia against Attorney General 2005, the applicant charged with criminal breach of trust applied for certiorari to quash the Attorney General's request to foreign judicial authorities in Hong Kong, Switzerland, and Japan. The request involved the taking of oral evidence and production of documents relating to financial transactions. However, the court dismissed the application, ruling that under Section 8, Subsection 1 of the Mutual Assistance in Criminal Matters Act 2002, the Attorney General had the statutory authority and discretion to make such a request. Since there was no excess of jurisdiction, certiorari was not granted.
The third issue, which is the error of law on the face of record, arises when a decision-making body such as a tribunal or lower court makes a legal mistake that is clearly identifiable from the record of the proceedings. This error must be obvious without needing additional evidence beyond the written record. It typically involves misinterpretation of the statutes, incorrect application of legal principles, or failure to correctly follow legal rules. For example, if a tribunal decides a case based on an incorrect understanding of the law or uses a rule that doesn't apply to the situation, this would constitute an error of the law. The courts may issue a writ of certiorari to quash such decision when this error is evident. However, not every legal error will justify intervention. It must be clear and fundamental, affecting the legality of the decision itself. This can be illustrated in the case of Kejuruteraan Samudra Timur and Seli Mando and another, where the applicant sought to quash the decision of the industrial court for the constructive dismissal on grounds of legal error. However, the High Court refused to grant certiorari as no clear error of law was found on the face of the record. The decision was made in good faith and within the legal limits of the industrial court, thus reinforcing the requirement for a visible and material legal mistake for certiorari to be granted. Furthermore, in Tau Realty, Senior Berhad and Ketua Pengarah Hasil Dalam Negeri and another, the applicant alleged an error of law in a tax evaluation but failed to appeal through the correct legal process. The court held that even if an error existed, the applicant had bypassed the proper channel, which is the Income Tax Commissioner, thus invalidating the request for certiorari. This case highlights that legal errors must be pursued through appropriate procedural routes and that misuse of judicial review processes can undermine a claim. Lastly, on the issue of procedural defects occur when a decision-making authority fails to comply with required legal procedures during its determination process. This includes situations where a body exceeds its jurisdiction, violates principles of natural justice such as failing to provide a fair hearing, or disregards mandatory procedures set out by the law. Such defects render the decision legally flawed and subject to judicial review. But not all procedural errors will result in the decision being quashed. For example, courts distinguish between mandatory and directory procedures, in which failure to comply with mandatory procedures often invalidates a decision, making it void, while non-compliance with directory procedures may not, unless it results in prejudice or unfairness. When the authorities fail to follow legal procedures, such as not granting a fair hearing or ceding jurisdiction, certiorari may be granted. For directory procedures, certiorari will not be granted, while for mandatory procedures, certiorari may be granted. To illustrate, in Wong Yet Eng and Tin Chang Fu, the appeal board missed the statutory time limit to make a decision. The federal court held that the time requirement was directory, not mandatory, meaning the failure to meet the deadline did not automatically notify the decision. This case is important for understanding that not every procedural misstep leads to invalidation unless it breaches a fundamental rule or causes injustice. Next, in VC Jacob against Attorney General, the plaintiff argued that the dismissal from his job lacked sufficient evidence. However, the court ruled that certiorari could not be granted solely due to the insufficient evidence unless the decision was based on no evidence at all. This case emphasized that the court's role is not to reassess the merits, but to ensure that procedural fairness and legal processes were correctly followed. There are recommendations for breaches of natural justice, excess of jurisdiction, error of law on the face of the record, and procedural defects. Authorities must ensure that their decision-making processes strictly comply with the legal standards of jurisdiction, natural justice, and procedural fairness to prevent abuse of power. The first recommendation is that it is essential to ensure training of administrative officials on the legal limits of their authority and the principles of natural justice, because many violations such as denial of fair hearing or decisions made with bias occur due to the lack of understanding. So regular training will equip officers to uphold the standards of fairness expected under the law. The second recommendation then is that administrative bodies should encourage internal reviews to detect and correct excess jurisdiction and procedural errors before final decisions are issued. This internal checking mechanism can reduce reliance on judicial review and help maintain public trust in administrative fairness. And Parliament should also revise and clarify legislation to set out a clear limit on what each administrative body can and cannot decide. Moreover, decision-making bodies should adopt standardized, transparent procedures when dealing with matters that affect individual rights. This includes providing adequate notice, disclosing relevant evidence, and allowing the affected party an opportunity to respond. To enhance legal compliance, agencies should also implement checklists to confirm all procedural and legal requirements are satisfied before finalizing decisions. These practical tools help prevent inadvertent breaches and ensure consistency in administrative practice.
In conclusion, the writ of certiorari serves as a crucial judicial remedy to address breaches of natural justice, excess of jurisdiction, errors of law on the face of the record, and procedural defects. These issues arise when the administrative or judicial bodies fail to uphold basic legal principles such as the right to a fair hearing or the obligations to act within the bounds of their lawful authority. Upholding the doctrines of audi alterum partem and nemo judex in causa sua is essential to ensure fairness, transparency, and impartiality in decision-making processes. To reduce reliance on judicial intervention and to promote lawful administration, authorities must adopt proactive measures. This includes regular training of officials on legal boundaries and natural justice, internalized mechanism for review, standardized and transparent procedures, and the use of compliance checklists. Only by embedding these safeguards into administrative practices can decision-making processes maintain legitimacy, prevent abuse of power, and uphold the rule of law.